welcome to the Monday, December 17th, 2012 meeting of the Lewis County Board of County Commissioners. This will be our last Board of County Commission meeting of the year. The next 2 days fall on days before holidays, and we won't be meeting on those days. So I will begin this meeting. I decided there is a quorum. All three commissioners are present, and we begin with the flag salute. Commissioner
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Mr. Chair, I move to approve the minutes of 10 December 2012.
Second.
Motion made and seconded to approve the minutes of December 10th. Are there any additions, deletions, or corrections? Hearing none, all in favor of the motion, signify by saying aye.
Aye.
Opposed, nay. Motion carries. Public comment for BOCC meeting, Ron Nelson.
Ron, do you want to talk now or at the hearing?
No, it's the other one, and you can mark my name off that list.
Okay, thank you.
Mr. Chair, I'd like to modify the agenda and add a proclamation this morning.
Second.
Second.
We have a proclamation before us this morning that we kind of kept under our radar a little bit because we didn't want to know that. This is before the Board of County Commissioners of Lewis County, Washington, a proclamation designating December 17th, 2012 as Ron Averill Day. Whereas in 1959, Ron Averill embarked on a lifelong career of service, duty, and honor. When upon graduation from the University of Southern California, he was commissioned into the U.S. Army, where he served 2 tours of Vietnam, was the commander of the battalion at the brigade level, the Deputy Chief of Staff, Intelligence, Western Command, Commander, Intelligence, South Pacific, and ultimately retired and decorated colonel, most notably receiving the Bronze Star twice for military service. And whereas after 30 years of a distinguished military career, Ron Averill's service continued by dedicating his elected wealth of experience to the classroom, working as a professor of political science and dean of social sciences at South Sound Community College from 1991 to 2006. And whereas in 1996, Ron Averill expanded his legacy of service as a volunteer citizen, serving 8 years as chairman of the Solid Waste Advisory Committee and chairing both the Citizens Advisory Council and the Agricultural Committee for the Lewis County Planning Commission. And whereas from November 2006 to December 2012, Ron Averill furthered the journey into the political arena when he was elected as Lewis County Commissioner, during which he proudly served on over 30 boards, and through dedication, hard work, and insightfulness, he, along with his fellow commissioners, was able to successfully appeal and reverse an invalidity ruling by the Growth Management Act Hearings Board, allowing for opportunities for growth and jobs in Lewis County. And he also served the citizens of Lewis County well in his position on the Shales River Basin Flood Authority. And whereas Ron Averill continues to work tirelessly and faithfully as a dedicated church member and community volunteer, serving as lay minister and lector at St. Mary Parish, active member of the Twin Cities Rotary Club, Centralia Shales Chamber of Commerce, the Lake Mayfield Youth Camp Governing Board, and the former university JV coach of the men's soccer team at Centralia Team High School. And whereas Ron Averill embodies the ideals of good citizenship, public service, and patriotism, now therefore be it resolved that we, the Board of County Commissioners, do hereby proclaim December 17, 2012 as Colonel Ron Averill Day in Lewis County. We celebrate his accomplishments as a public official and his commitment to Lewis County and our country. We thank you, Ron, for your dedication to serve with devotion, integrity, and honor. We wish you continued success as you carry on to your next distinguished journey of service. Done in open session on the 17th day of December, 2012, Board of County Commissioners, Lewis County, Washington.
this morning. I just had 2 cavities filled in my right side of my face. But I do want to thank my fellow commissioners for the thought. It has been a real ride during the last 6 years. We have, I think, overcome some huge challenges from natural disasters, bad economy, and we have had the good fortune of having one of the best qualified, capable county staffs anywhere in my estimation in the state of Washington. The way that they respond to natural disasters, the way that they provide service, the innovation that we have experienced in one area after another, the fact that in a bad time, the state funding for our most disadvantaged people has been wilting away, and that we as a county recognized that we could not let these people suffer in this economy, and so we have taken the bull by the horns and done things to make it better for those people. We now have a home for the developmentally disabled in Centralia. We have a home that we can put our most mentally severe people coming out of our jail so that we can transition them into stabilized persons in our society in Magnolia House and the work that we're doing with the Lewis County Shelter. The fact that you as citizens accepted an additional tax so that we could take care of making sure that our drug court would be able to continue, and that we would be able to take care of the mentally ill and those who have chemical dependencies. These are huge and great achievements. I'm honored that I've been able to work with such professional people. I hope that my guidance has been helpful in this process. I apologize where someone thinks that perhaps I pushed a little bit too hard, was not as forgiving. But I want you to assure you that my heart was always for the citizens of Lewis County. I know that Edna will do a good job, great job, as a county commissioner, carrying on, because we still have challenges out before us. But we as a people, as we showed in 2007, can deal with adversity, and we can make this a better place to live, and a place that people want to come to. We need to grow, because if we don't, we will wither away. So I will be there cheering on the side, and if allowed, helping where I can. Thank you very much.
Be my spot. Thank you, Ron, for your service and your comments. They've been really appreciated and great to work with.
No, I'd like to move to approve the notice agenda.
I'll second that.
Moved and seconded to approve the notice agenda as presented. Clerk, please read those items for the record.
Item 1, notice informal sealed bidding with respect to purchases and leases under $25,000. This is resolution number 12-401. Item 2, notice of hearing regarding the proposed vacation of Johnson Creek Road East. Hearing will be held on or after 10 a.m. on Monday, January 14, 2013. This is resolution number 12-402. Item 3, notice of hearing regarding a non-exclusive franchise to Lakeview Terrace Water Group to construct, operate, and maintain water facilities on all roads within Lake Terrace Edition and Second Lake Terrace Edition. Hearing will be held on or after 10 a.m. on Monday, January 28, 2013. This is resolution number 12-403.
You're going to force me through this, Larry? Okay. Item number 1, resolution 12401, provides notice pertaining to competitive bidding pursuant to RCW 39.04.190 with respect to purchases and leases valued between $5,000 and $25,000, dispensing with advertisement and formal sealed bidding and notice of the existence of a vendor list and solicitation of names of vendors for that list. Authority for purchases or leases off of this list is effective for 1 year from the publication of notice and solicitation of vendors in the newspaper of general circulation in the official newspaper for legal indices. This is an annual thing that we do. Just renewing it and opening the list for new vendors. This is merely a notice. There's not going to be any hearing or anything. It goes out in the paper. So if there are any vendors who want to get on this list, they need to contact the assessor's office.
Good morning, Commissioners. Tim Alsey, Lewis County Public Works Director, speaking to items number 2 and 3 on your notice agenda. Item number 2 is a notice of hearing regarding the proposed vacation of Johnson Creek Road East. Resolution 12-334, passed by the Board of County Commissioners on October 29, 2012, declared its intent to vacate Johnson Creek Road East and instructed the county engineer to examine the road and report his opinion on the vacation as required by RCW 36.87.010. One property owner adjoins the entire length of the road on both sides, and they requested vacation. Utility companies known to service the general area have been notified. Public Utility District Number 1 of Lewis County and CenturyLink do have utilities on the right-of-way. RCW 3687 allows an easement for existing utilities to be retained over the vacated right-of-way, which in my opinion is appropriate in this instance. I have prepared a report on the matter which is hereby submitted. If the report is accepted, passing the attached resolution would set a January 14, 2012 hearing date for consideration of the matter.
2013, I hope.
Yes, 2013. RCW 3687-150 requires publication at least once a week for 2 consecutive weeks preceding the date fixed for the hearing in the county official newspaper, and that a copy of the notice be posted for at least 20 days preceding the date fixed for hearing at each termini of the county road or portion thereof proposed to be vacated. This is a little spur road off of Johnson Creek Road and has not been used as a county road for many years. It originally was part of Highway 12 and has not been used as part of that system.
You'll see that Tim was trying to compensate because the notice says that the hearing is going to be on Monday, 14/2012.
Actually, it was not part of US 12, it was actually part of Highway 5, State Highway 5, back in the day before the US system it was effectively known, with the even numbers going east and west and all numbers going north and south. And so that was part of Highway 5 at the time. And now it is abandoned, it's been, we've been with it for years and years.
It's also interesting that normally we cannot vacate roads if they have butt on a body of water, and we don't go down to the body of water very often. So this one does not.
No, it does not. Speaking to item number 3, notice of hearing regarding a non-exclusive franchise to the Lakeview Terrace Water Group to construct, operate, and maintain water facilities. Lakeview Terrace Water Group has requested a franchise for the construction, operation, and maintenance of water facilities on all county roads within Lakeview Terrace Edition and Second Lakeview Terrace Edition. This franchise would replace the existing franchise scheduled to expire on February 10, 2013. The franchise is proposed for a 5-year term. This resolution will set January 28, 2013 as the date for hearing on the franchise and call for required postings and publications as required by RCW 3655-440.
This said it was near Mossy Rock. Is this the one up by Mayfield Lake?
It is. Thank you.
Any other questions or comments on the notice? Hearing none, I'll call for the vote. All in favor, signify by saying aye.
Aye.
Aye. Opposed, nay. Motion carries.
Mr. Chair, I move to approve the consent agenda items 4 through 18. Resolution number 12-404 through 12418.
Second.
Motion made and seconded to approve the consent agenda. Will the clerk please read those items into the record?
Item 4, resolution number 12-404, approval of warrants for payment. Item 5, resolution number 12-405, cancellation of warrants. Item 6, resolution number 12-406, approving the time and place for tax foreclosure sale. Item 7, resolution number 12-407, approving an intergovernmental cooperative purchasing agreement with the Department of Enterprise Services. Item 8, resolution number 12-408, amending the county section 125 cafeteria permit. Item 9, resolution number 12-409, approving local government restricting altering precincts within the city of Centralia. Item 10, resolution number 12-410, approving the internal placement of extra help appraiser 2 at grade 18 on the Lewis County salary grid. Item 11, resolution number 12-411, approving an interlocal agreement with the city of Centralia for labor relations services. Item 12, resolution number 12-412, approving a contract with Lewis County Shelter Program to provide funding to support high utilizer services. Item 13, resolution number 12-413, approving a contract with Reliable Enterprises to provide funding to support high utilizer services. Item 14, resolution number 12-414, approving contracts with Community Alliance Behavioral Health, Eugenia Center, and Fresh Start for drug, alcohol treatment, and prevention services. Item 15, resolution number 12-415, approving the 6th supplement to this personal service agreement with West Consultants. Item 16, resolution number 12-416, approving transfer station host fee agreement between the city of Centralia and Lewis County Solid Waste. Item 17, resolution number 12-417, approving consultant selection for structural design of Looting House Bridge replacement. Item 18, resolution number 12-418, approving a name change of Winter Road near Winlock to Winter Road.
Item 4, resolution 12404, approves 14 special purpose warrants for Baker Water System for $14,833.85, and 331 warrants issued by the Auditor's Office for $1,442,539.56, totaling $1,457,373.41. Resolution 12405 approves cancellation and reissue of 2 warrants issued by the Lewis County Auditor's Office, totaling $1,680, which were lost or destroyed. Item 6, resolution 12406, approves a request from the Lewis County Treasurer's Office to use this Commissioner's meeting room on the 2nd floor of the historic courthouse building for a tax foreclosure sale on or after 9 a.m. on Friday, January 18th, 2013.
Gabe was going to address that.
Gabe was going to address that. I didn't catch you, Gabe, sorry.
That's all right. The Treasurer Office has obtained a judgment of order of sale for closing upon its tax liens. Currently, we have 48 parcels with, along with 26 tax title parcels that we will sell. The tax title parcels that we'll sell were addressed in Resolution 12-306. RCW 8464080 requires that the county legislative authority direct the time and place of sale. We would like to suggest to the board 9 a.m. Friday, January 15th, 2013. Also, we'd like to ask you, the Commissioner's meeting room.
Gabe, I presume this includes the parcel that we remanded back to the Treasurer for sale?
Yes.
Thank you.
Thank you.
Gabe, can I have a couple questions? Just kidding. I didn't hear what you said, but that's probably a good thing.
Resolution 1247 approves an intergovernmental cooperative purchasing agreement between Lewis County and the Washington State Department of Enterprise Services, allowing Lewis County to purchase a variety of products and services from the cooperative at a discounted rate. The agreement is for a 6-month period through June of 2013 at a cost of $1,500. The example products include such things as office supplies, janitorial supplies, and vehicles. This is normally a year contract, but the state has announced that they're going to be restructuring this cooperative, and so in June of 2013, have to decide whether they want to continue and on for the next year. You want to get the cafeteria plan?
Where would you address it first? Since most of the Affordable Care Act is not understood by the people that passed it, we're going to ask Larry to interpret it for us.
How much time do you have? So basically, the county section 125 plan, which is pre-tax for medical related expenses for employees, the cap has been historically $4,800, and under the Federal Affordable Health Care Act, it's being reduced to $2,500. So we're amending our plan to conform with the federal requirement. Essentially, it's a way of getting more tax dollars for the federal government to pay for affordable health care.
In your description that you provided, I understood coming down to $2,500, but in the resolution itself, is there another $2,500 that the county can?
No, it's $2,500 cap per employee.
Unfortunately, which one is that? 5, 7, 7. The wording that I'm having trouble with, Larry, is notwithstanding any provision contained in the county health care flexible spending account, to the contrary, the maximum annual contribution amount that may be allocated to the health care flexible spending account benefit may not exceed the lesser of the participant's salary deduction election for the plan year, or $2,500 plus any employer contributions that may be made.
Yeah,
But we don't make any, so that's why you're saying
that's correct.
25.
That's correct. And employees typically elect less than 2,500 except for exceptions. And it will be indexed in future years.
Just another explanation for people that use this plan, it allows them to pay for medical and some child support.
So child support separate is $4,800 a year for Medicare.
And this is before taxes.
Correct. So every dollar they earn pays for a dollar of medical. So it's a really good deal.
Thank you.
Thank you.
Item 9, Resolution 12409. Do we have someone that's going to cover that? This approves adoption of the local government redistricting, altering precincts in the city of Centralia. Centralia has 13 precincts contained in 4 wards or council districts. As a result of the 2010 federal census, it was necessary to adjust the boundaries of the wards to proportionally equal populations, and subsequently to alter the precincts within those boundaries. The City of Centralia has approved these changes, and Lewis County Public Works GIS Division has produced new precinct maps pertinent to the City of Centralia. RCW 29A.16.050, Parents 4, requires the Board of County Commissioners to formally adopt the changes. So now your legal secretary. Will be.
Good morning, Commissioners. Archie Smith of Lewis County Human Services, I'm here to present items number 10 and 11 on the consent agenda. Item number 10, resolution number 12-410, is approving the initial placement of an extra help appraiser 2 at grid 18 on the Lewis County salary grid. When we look at casual employees, the current existing grid, as we may call it, the 13-step M grid, has a limited range for casual employees, and all casual employees fit within that grid. When we get into technical positions, what we generally do is come and present a resolution to go outside that casual grid, and this is one of those situations where in the assessor's office, due to a vacancy of the technical position, the sales analyst that the assessor is trying to recruit for and fill, she is having to move employees around to cover those duties, and she's also down that position, so she's requesting a appraiser 2 hired into that appraiser 2 grade to be able to go do the work that the appraiser that is doing the sales analyst work is doing, so she can cover those duties and stay within the appraisal requirements.
So the maximum casual can get is $13.49 off the grid.
Yeah.
And by using grade 18 on the grid, the range is $18.87 an hour and $25.38 an hour.
Correct.
So I presume that's what they'll choose somewhere in that track.
Has this position been hired over here, is they still looking?
Say again, sir.
Are they still looking for someone to fill this, or is it
They are still looking for someone to fill it. It is quite a technical position, and there's not a lot of people just out there. You're generally, I think, trying to pilfer someone from somebody else who's going to train. That's where the quandary comes in for this position. All right. Next one is item number 11, resolution number 12-411, approving an interlocal agreement with the City of Centralia for labor relations services. Basically, the county was contacted by the City of Centralia to conduct labor relations for them on their existing contracts. And the time frame for this agreement is October 1, 2012 through October 1st, 2013. It provides for approximately 10 hours of labor relations services a month at a rate of $63 an hour.
And what are you providing?
What's that, sir?
What will you be providing?
I'm actually acting as their lead negotiator for 3 of their open contracts right now. One is their Centralia PD, their non-commissioned PD, which is their clerical, and then their clerical group.
Thank you.
Tonight, your Director of Public Health and Social Services speaking on items number 12 and 13. Resolution number 12-412 is approving a contract with Lewis County Shelter Program to provide funding to support high utilizer services. This is part of the sales tax that you implemented earlier this year. And what the shelter will be doing for this total of $85,000 is having 4 additional beds for single men and 4 additional beds for single women at their shelter, where they can house these individuals that have been qualified as high utilizers of the jail system. So when they come out of the jail, they'll have somewhere they can go instead of on the street. This contract will go from November 1st of 2012 through October 31st of 2013.
And that's for $85,000.
$85,000. And resolution number 12-413 is, I'm sorry.
We need to note that this is a short-term contract with the shelter program for 90 days, not exceeding 90 days.
The contract is for a year, but the individuals that go to stay in the shelter can only stay there for 90 days. And the shelter does have staff that provides case management and attempts to find them another place to go to when they reach that 90-day limit.
Thank you.
And item number 13, resolution number 12-413 is also a sales tax contract. This is for $65,000 and is a contract with Reliable Enterprises to provide funding to support high utilizer services. And this is in reference to the Magnolia Place that Commissioner Averill spoke about earlier. They provide case management using the practice called critical time intervention, and it's a 9-month long process. So the individuals coming out of the jail can go straight into an apartment at Reliable Enterprises, or if it's available after they go through the shelter program for the 90 days, they can go to Reliable Enterprises and get a place at Magnolia. They have to agree to go through the 9-month critical time intervention case management. And this contract it actually started earlier, so it's from September 1st of 2012 through August 31st of 2013.
And how much?
$65,000.
This is really an important contract. One of our problems that we have is that the folks that have mental illness and are in jail, they have those that are in the worst condition oftentimes have trouble finding a place to live because they've trashed apartments all over town and they're on lists and can't get a place to live. And secondly, they've proven over time that they're not very good at managing their medications, and they need extra support. And this, when we started to look at how to tackle this problem in the Mental Health Coalition, the two things that came up persistently were a need for places for these people to live and for case management. This is going to do this, unfortunately, for far too few people. We estimate that there are 16 at a minimum that roll through the jail on a regular basis. And this facility, I believe, has 5 permanent beds.
That's correct. And 2
transition beds in it. But worse than that, they don't necessarily have to leave when their 9-month program is over. So if we have someone staying there for a long time, that's someone else that we can't push into the system. So, and then we still have work to do.
Please note that even with this, we still have those issues out there. But I also want to note that it does show that we're not doing nothing about this situation, and we are trying our best with limited funding that we have to take care of people in the community that have those kind of problems. I listened to President Obama's speech several times with the Connecticut situation, and we don't know what prompted that whole situation back there, but suspicion is that this young man has some serious mental problems, so hopefully we can save something like that off.
Thank you.
Yeah, while she's going away and the next person is coming up, mental health is a problem in our community that oftentimes we as citizens try to sweep under the rug. And it's becoming a far more difficult problem because the state has gradually moved itself out of business and reduced the beds at the Eastern and Western Hospital for the most serious and mentally ill, and putting those folks back on the community. Unfortunately, all too often, they end up in our jail, and jail becomes the provider for these mentally ill. I think this is an area where the state legislature really needs to take a look. You know, we're having people now yelling that we got to get rid of guns, we got to get rid of guns. And I understand that there are some people that have fear, but I also can tell you that you can kill a person with a knife, with an arrow, with a stone, with a bludgeon, and these people will do that. It's what we need to attack is the problem of mental health. We need to do a far, far better job. We particularly need to find these people that are seriously disturbed and get them help. It's not just this Sandy Point School or Columbine or the 4 police officers that were killed up in Lakewood. It is a serious problem and we have to get serious about it.
Thank you, Commissioner. Tara Smith, Lewis County Public Health and Social Services Manager, speaking to item number 14, resolution number 12-414, approving contracts with Community Allied Behavioral Health, Eugenia Center, and Fresh Start for drug and alcohol treatment and prevention services. This contract provides treatment funding from the Division of Behavioral Health and Recovery Services to community providers for individuals in Lewis County who are identified as having a chemical dependency addiction and are low income or indigent with no income. The total contract amount is $480,179. This contract is for July 1, 2012 through June 30th, 2013.
Do you want to go ahead and give the amounts that are provided to each of the regions?
Certainly. Community Alley Behavioral Health has a total contract amount of $156,862. Eugenia Center and their regular contract is $111,000. The Eugenia Center CJTA contract, which is used for treatment for drug court clients, is $128,078. And then Fresh Start is $84,239.
So the Eugenia contract is the one primarily supporting the drug court.
The treatment portion, correct?
The treatment portion thereof. And the rest are for other folks with chemical dependency problems in the community. And the drug court does a wonderful job. It's something that we need to continue to support, but it can only handle a limited number of clients. And we've got over 1,000 cases of chemical dependency in this county. And so it's the community and allied behavioral health, partially Eugenia Center and Fresh Start, providing these clients the support they need.
Tara, to avoid any misunderstanding, what are the funding sources?
The funding sources that fund this treatment through these contracts comes from federal and state sources. The CJTA funding is a special legislative appropriation to serve anybody in the state of Washington who has been charged with a crime and has a chemical dependency issue, and then it's up to each individual county to decide locally how those dollars will be spent in our county, and it's used for drug court treatment. And so everything is state and federal.
Lee Napier, Director of Community Development, speaking on agenda item 15, Resolution 12-415. The review and the action today is concerning a supplement. This would be the 6th supplement to a personal services agreement between Lewis County, acting as the fiscal agent for the Chehalis River Basin Flood Authority, and West Consultant Inc. They're the consultant that was retained to support the Flood Authority for their early warning program. The scope of work before you today was reviewed by the Flood Authority when the scope of work and compensation for the 5th supplement were authorized by the Flood Authority and the Board of County Commissioners. And contained in this scope of work are the services to maintain service for the flood early warning system and to pay web subscription fees. The funds for the contract will come from fees charged to each member of the Flood Authority. So there is a proportional share that has been determined, and a copy of that was included as part of this attachment. And so the members' proportional shares will be billed, as I understand it, 2 bills in 2013. This scope of work has additional compensation in the amount not to exceed $53,585. And so before you today is to approve the resolution and authorizing the Director of Community Development to sign the 6th supplement to the Personal Services Agreement with West Consulting.
Just as a clarification, we actually started in June, and so all of the 12 jurisdictions, who I'm glad to say all have agreed to pay their share at this point, so it's no longer a concern of ours, but we paid through the end of this year, and now we've got 2013 to pay for. And for some jurisdictions, it's hard to pay the entire years at once, so we're allowing that they can spread that out either semi-annually or quarterly, but they need to tell us if that's what they can do.
That's correct, and we'll be working with the jurisdictions, starting with the Flood Authority. Hopefully a brief announcement, since there's only an hour on Thursday, but we'll let them know that this has been approved and get working on that right now. Thank you.
Good morning, Tim Elsey, Lewis County Public Works Director. Speaking of items numbers 16 through 18 on your number 16 is approving the transfer station host fee agreement between the City of Centralia and Lewis County Solid Waste Disposal District and Lewis County. As you're aware, in 1994, Lewis County and the cities within the county created the Solid Waste Disposal District number 1 to handle all of the municipal solid waste that was collected within the county. At that time, we developed a rental agreement between the district, the city, and the county for lease of the property because, of course, the landfill sits on city property. The terms of that agreement virtually have remained unchanged since 1994, and that agreement will expire on December 31st of this year. We propose to make some changes to that agreement. Basically, rather than charging $4 per ton for the MSW that goes out of the central transfer station, we're charging 4.75% of the tipping fee for the waste that goes out of the central transfer station. This does not include any recycled materials. It doesn't include any other types of waste, or from any waste that goes from the Morton transfer station, just the material that goes out of the central transfer station. And if you approve this resolution, it will authorize the chair to sign the agreement.
Want me to explain the Berg codicil?
I'm sorry?
You want to explain the Berg codicil?
This agreement will allow 30 tons of material to be donated to the city as part of this agreement so that they can do cleanups as they did this year. They had a house that they wanted to clean up.
There was an abandoned house in Market, I believe, that was right there in the corner of Centralia College and on the Centralia College Boulevard. I guess the Police Protective Society, as a charitable project, agreed to help tear that down. And this year, they came to us and said, can we throw this stuff away free? Well, unfortunately, the solid waste fund is a fund that is paid for by ratepayers who have their garbage picked up and brought to the facility and taken out of the county. So we can't gift those funds, but we did have a program where you could have vouchers. We allowed them to pool vouchers together. And it was, as I recall, about 1,000 vouchers they needed to pool together in order to get rid of that.
It was near 30 tons. Speaking to item number 17, approving the consultant selection for the structural design of the Looting House Bridge replacement. This is a milestone today. This is the opportunity to be able to hire a consultant to design the replacement of the Looting House Bridge, which of course was washed down in 2007. This agreement in front of you today is for $356,654, and it's for design and construction engineering of a truss structure located about a half-mile upstream of the previous structure. This will be at Hatchery Road. So this resolution today, if approved, would allow me to sign the agreement with Berger Avon for the design and construction engineering of the new structure.
Is this going to be a clear span bridge?
It will be a truss bridge.
But it's going to be up.
Oh, clear, yes.
Higher.
Out of the 100-year floodplain, yes.
It will be similar to Chandler, or not?
It will not be similar to Chandler. This is a steel bridge. Chandler was a concrete bridge. And that's because steel bridge will allow us to have less of a beam and the grades going up and then back down to the roads will be less. It's a little bit more of an expensive structure generally, but in situations like this, it's warranted.
This is the last of the bridges that we needed to replace after the 2007 flood. There was another bridge that was at the Rainbow State Park, but the Park Service does not plan to replace that bridge. And so right now, if you're going to the park, you've got to drive all the way up to Chandler Bridge and come back down. So this will allow a second entry into the park.
That's correct. And we've had several public meetings on this. The folks in that area have just been amazing to work with. They've been through a lot. And like I say, this is a milestone to be able to replace this bridge. This will be paid for 75% by FEMA, 12.5% by DEM, and 12.5% by Lewis County.
And construction will start when?
2014.
Just check.
I get asked that a few times a week. Item number 18 on your agenda, approving a name change of Winter Road near Winlock, Washington to Winter Road. Winter Road is a county road located just south of Winlock. The road was originally named after Frank Winter Road, one of the citizens who petitioned for the county road back in 1907. Since then, Winter Road has caused some confusion for the residents down there, and they have petitioned to have the road changed. The road does not conflict with any other road names within the county, and we recommend changing the road to Winter Road from Winter Road.
So why didn't we solve the problem by calling it Winter Road Street or Winter Road Avenue?
That might have seemed a little not helpful.
Far be it from me.
Thank you, Jim. That concludes the audit section of the consent agenda. We have a motion on the floor. Any other comments or questions? Hearing none, I'll call for the vote. All in favor of the consent agenda, signify by saying aye.
Aye.
Aye. Opposed, nay. Motion carries. We have our annual comprehensive plan amendment hearing next on the agenda. Larry Osman, meeting talked to you after a while, so you go back, I can call you and give you a call. Our annual comprehensive plan amendment, and we have our regular hearing schedule where we'll have a work session and consider the yearly amendments, and I think we make a motion to hold these in the same hearing and the workshops together. That's what I intend to do. So we'll have a staff explanation of what's going on, and we'll follow that with a question and answer period. And then we'll open the hearing up for public comment and testimony. I will re-emphasize that there are two opportunities. One, to ask questions of the staff after their presentation of what we're doing. So that will be a question and answer period. So that will be questions directed to the staff to clarify any misunderstandings that there may be in their presentation. Following that, we will hear comments on whether you're in favor of or opposed to the comprehensive plan as it's presented. So the first thing we do is ask questions. The second thing we do is have comments. The comment period will be limited to 3 minutes. Having said that, we've covered everything, Mr. Carter. If not, if we have, then we'll proceed. Staff, thank you.
Stan May, Community Development. So we have 3 items on the for the comprehensive plan Title 17 zoning code change this year. They are all 3 are familiar to you. You've seen them all before. Forecastle repeal, and is the first up that I'm going to talk about. We have the Hampton lumber rezone, and this is more of a correction than it is anything else. And then finally, we have the Gaspill property rezone, which was remanded to the Planning Commission for reconsideration. So I'm just going to walk through each of these one time, whether it's because all of them affect the comprehensive plan and Title 17. So rather than looking at them 3 individual times. The first one is the Forecastle property. This was part of Ordinance 1219, Section 5, and Resolution 10-359, Section G. And they were redesignated 830 acres of forest land of long-term commercial significance to forest land of local importance. This redesignation was appealed to the Growth Management Hearings Board, and the Hearings Board found the county not in compliance and issued a final decision and order in August of 2011. The county filed a motion for reconsideration, which was denied. The county filed a petition for review of the final decision with Thurston County, and the judge found in favor of, basically affirmed the final decision. The county filed its report of compliance, and the hearings board found that the county failed to comply still. So finally, in discussion with the proponent, the applicant Forecastle, and the county, it was decided that probably the best course of action was to revert the property to its original designation of forest land of long-term commercial significance. And in October, the board directed staff to go ahead and initiate the reappeal process.
Yeah, I'm going to have to interrupt here because I think this needs clarification. The original zoning that we did on Meadow Lake was not in compliance. What was found not in compliance was that it created a new category in the board's estimation that we had opened to other people in the county. And we were asked at that point to do that. And in the process, or perhaps Glenn, you can explain all better.
Well, the essence of what you say is correct. The issue was that the board believes that there are at least 30 other properties in the county that if this property, the Forecastle property, is entitled to long-term or to local importance, that those other 30 or so properties are also entitled to local importance, need to be reclassified and redesignated as such. However, to do so would require a great deal of study, a great deal of effort to go out to each of those properties and to determine if they comply with the local importance requirements of that classification and designation. Also, some of the petitioners believe that there may be other properties in addition to those 30 that are entitled to local importance and consideration. And the essence of it is that the board believes that unless you do this uniformly across the county as to all of those potential properties, that you are inconsistent in finding that one of them is entitled to local importance and that those other 30 or so, whatever the number is, are not. So we have right now, in the board's estimation and pursuant to their compliance order, we have an inconsistent comprehensive plan. So we can either, as I say, go in, redefine what is contiguous within our classification and designation ordinances, redo them, reopen FRL, go back, reclassify, and redesignate all of our FRL, taking into account those new criteria. Or we need to achieve consistency by basically rescinding what we did with respect to Forecastle. In this case, we tried compliance once already, which failed. And so at this point, staff has determined that the appropriate way to go is to rescind the reclassification and redesignation of the Forecastle property and to restore it to what it was before we made the initial decision back in 2010.
So Glenn, in effect, then, are we saying to the group back in hearing board that our opt-in option that we had in our ordinance is no longer valid?
The opt-in, what the board would say is that the opt-in is valid as to certain properties, as long as those properties are small. So the opt-in, you recall the last time we did the compliance process, we had approximately, I'm not going to recall the exact number, maybe 8 small properties that were designated as local importance back in 1996 to 1998. And those properties were all smaller than the 80 acres and smaller than the 5,000 acres. Because remember, for forest resource land of long-term commercial significance, you have to be contiguous to 5,000 acres. And these lots were small and they were isolated. As to that kind of property, it can opt in and could conceivably do so still. But with respect to those that are at any time part of a contiguous, large contiguous 5,000 acre block, those cannot be designated as local importance without some further justification. And in this case, the justification was to redefine what contiguous meant. The growth board did not accept that. But there could, the growth board in their decision, compliance order says that there might be circumstances where reclassification of something that once was 5,000 acre block could be local importance, but it's very narrow and it didn't apply in this case. And what the growth board says is that that case wasn't before them.
Continue.
Okay, the next item is the Hampton Lumber property out in Packwood. This was a property that the original request for a rezone from small town industrial to small town mixed use included basically cut across 3 different parcels that were all owned by Packwood Lumber. They asked for the southern portion to be rezoned, and then they had agreed that they would also do a boundary line adjustment to match the rezone after the fact. So their original request was for one contiguous piece of property. Somewhere along the line, it turned out to be what was actually approved was 2 pieces of property that are 2 parcels of the 3, but it didn't include the portion in the middle. And so this is coming back through to basically correct that. In the meantime, Hampton Lumber has done a simple segregation to reconfigure their properties from, I think they had 5 parcels altogether that were affected, and it's been reconfigured to where there are now 3. The southernmost one is the one that they are asking to, is what they originally asked for to be rezoned.
So are we rezoning all 3 or just the southern?
Well, it's actually going to affect, right now, since it got rezoned improperly in the first place, the wrong areas. So it's going to be the mixed use will be pulled off of 1 parcel or off of 2 different parcels, and then it'll be applied to the 3rd parcel. So it affects several of their parcels. Again, they're all the same.
You want to explain to us, because it was originally small town industrial.
Yes.
And now we're going to mixed use. So
yes.
The difference is?
The difference is that industrial has a limited development potential for any sort of commercial or residential uses in Packwood, whereas this mixed use allows it to do a commercial and residential development of some sort, similar to other areas of the small town of Packwood.
And this is at a higher density than they would be under either the Lambert or the RDD?
Actually, small town mixed use is a Lambert in Lewis County, and so yes, it will be basically comply with that small town mixed use zone, which is a Lambert zone.
The property is within the Packwood Lambert.
Excuse me?
The property is within the Packwood Lambert.
Yes, it is. It already is within that property. It's just rezoning it within the Lambert. Okay, if
the Lambert is a limited area of more intense density.
Yes.
Rural development.
More intense rural development.
Okay, the third item is the gas field property, which the board remanded to the Planning Commission last year.
It was 2 years ago.
2 years ago, my mistake. Anyway, it was originally recommended, the Planning Commission recommended against rezoning, fearing it would be seen as a spot zone. So when it came back to the Planning Commission, we took another look at it, did another analysis of the properties. What we found was that there are, the property itself is steep slopes and wetlands. Only a very, very minor portion of it is designated as prime soils. Most of it is either prime soils that drained or steep slopes. So it's the properties directly to the east and to the west are both parts of two separate 300-acre farms, all of which are being farmed except for the portions that are directly adjacent to the gas field property. So what that really means is that it really isn't necessarily a spot zone, because a spot zone means that we're going to take and treat one parcel differently than we would treat anyone else, and that have similar circumstances, but it's not ag land. It's just like these other two properties. But these other two properties aren't going to come in and ask to be rezoned, because most of their property is being farmed, with the exception of the ones adjacent to gas field. Also, there are properties directly across the highway adjacent to gas field that are ranging from a couple of acres up to about 20 acres. There's about 11 properties that all but one or two of them have residential developments on them. So again, by redesignating the gas field from ag land to RDD 10 is not going to be any different than the properties adjacent to it in any of three directions.
In defense of the Planning Commission, one of the problems, Mike would back me up on this, but one of the problems that we have when we're doing planning in this area is that we tend to paint with a rather broad brushstroke. And so we could get into issues of, is this entire parcel in an agricultural resource land, or is it 20%, 30%, 40%, 60%? And the other problem with the spot zoning was that when we're doing agricultural resource plan, the whole intent of agricultural resource land is to provide maximum area to provide farming, whether that be animals or crops. And so you try to leave as much area for an agricultural farm as you can possibly leave. And so the Planning Commission kind of looks at the entire area and making that decision. This overlooks the fact of geography and topography. And any of you that drive through Lewis County know exactly what I'm talking about, where you have an area that looks just like it's prime flat farmland, and then there will be an upcropping in there, or we'll meet one of the other criteria that we have to guard against, and that's wetlands and critical areas and things of this nature. So it is a difficult job for the Planning Commission to walk this line and keep it. I said this has been in there for 2 years, and I appreciate Mr. Gasfield's patience with this. But the original look at the Planning Commission, when it came to us here, we asked that it go back. Unfortunately, this is a year-long process to get here, and the Planning Commission re-looking at it has changed their mind. So.
Any questions from the board?
I have a couple of questions. This Mineral Lake development,
Yes.
the proposal that you were rescinding would develop how much of that property?
I'm not sure I understand. Develop how much of the property?
When we changed the zoning on that, it's my understanding that part of the property was going to be developed and part of it was going to put into some kind of conservation easement.
We're basically asking to repeal the entire ordinance.
That's what it did.
Yes.
Originally, it was about 830 that's rezoned, and 1,250 acres that was put into reserve that And reserve meaning that it could never be developed for residential purposes.
So we were putting some limits on developing and protecting some of the property.
Even as to the 830 acres, they would be managed as forest lands. And the property that would be developed most directly would be the place where the home is placed, where the house is placed, which I believe was limited to 1 acre, as I recall.
And so now that they are going to be rescinded, all of this land can be developed.
All of the land is subject to 1 in 80 zoning.
It'd have to be an 80-acre lot, but there could be a house on that one.
Yes.
That 80 acres.
So all of it is potentially developable now. So by rescinding this, we've removed protection from half and allowed development and cutting on all the property.
All of it that was subject to forest management, yes, that's right. But there is on the 1,250 acres, the forecastle themselves chose to put on pursuant to our requirement with the original 2010 decision. They did impose covenants, conditions running with the land, CC&Rs, that restricted, as I say, residential development. Now, it's up to them what they do after you rescind that ordinance. But at the moment, it provides for no residential development. But yes, generally under forest resource land of long-term commercial significance, there is development permitted at 1 in 80 acres.
So those agreements that we made to limit development are gone, and they will be able to develop the whole property.
The limits that we required in the CC&Rs could be lifted by the private landowner because they are no longer required by us.
So the whole property is potentially available for development.
At
So
1 in 80.
by rescinding this, we didn't protect any of the land. We actually opened it all up for development.
Some might see it that way, yes.
Well, actually, it was all open development under FRL before our previous discussion.
That's right.
And so we haven't changed anything from what it was back in 2010.
Precisely.
Any questions from the audience? Mr. Wilson, step up to the mic, state your name and address, please.
One question or a couple questions. One is the DNS. Is the DNS going to be, for the forecasted property, is it going to be null and void if the repeal stands?
The DNS, which is the determination of non-significance, which applied in the first round of compliance, which included a proposal, a potential proposal with respect to that property, was withdrawn by the county. So when you withdraw the DNS, it's no longer an effective order. It was withdrawn as if it no longer exists.
Okay. And then comments about the CC and Rs. Roberta will
Would you
present
please
CC.
spell those out for folks that don't know what CC&R is?
What, would you explain what a CC&R is? The people out there that don't know.
Roberta, what is it?
Covenants, conditions, and restrictions.
That forecastle submitted to the auditor's office as a record. Those CC&Rs did not protect the 1,200 acres. So any discussion or comments about forecastle did protect the CC, or did protect the 1,200 acres, it isn't true. If you read the CC&Rs.
Now, so you're asking a question, you have a question for the staff, I appreciate you asking the question.
The question is, did the CC&Rs protect the 1,200 acres from residential development?
It's really an irrelevant question because the CCRs are no longer in effect with this change.
May I make one comment? Sure. Chairman? The CCNRs, as I understand it, are still on file and still recorded. They are no longer required by the county if the county board today rescinds that ordinance. As to the legal effect of the CCNRs, it would be, if you wish, that's something for you to ask your lawyer. Different lawyers might have different opinions concerning it.
Okay.
Are there any other questions? Seeing no further questions, I will close the question and answer period and open up the comment period and ask if the previous comments presented by staff, would you like them included as part of the hearing?
Yes, Mr. May and I would please request that you incorporate our comments from the question and answer period into the testimony period.
So we'll open up for public comment first from the board. If you have any comments?
I just have one. I mentioned that Mr. Gatsfield has been very patient with us over a 2-year period because, unfortunately, when you got into growth management and the growth management planning process, there are things over which we have no longer any control. And one of those is that it takes a year to go through the process of the planning commission and the hearings and everything to make decisions of what changes we're going to make in the plan so that a property owner who wants to have a change can move forward with their life in their possession. I'm sorry that it's taken this long, but I think we finally got what you were looking for when you came to us 2 years ago, and I thank you for your patience.
We have 2 members of the public signed up for public comment. Ron Nielsen. State your name and address for the record, please.
My name is Ron Nelson. I live in Mineral. I'm representing myself and also as coordinator of Friends of Mineral Lake. I have 3 letters here I'd like to submit to the record. They're too long to read in 3 minutes. Here they are. This is all about Forecastle and Mineral Lake property. I have one letter here I'd like to read because it is short. Speaking for myself and as coordinator for the Friends of Mineral Lake, I recommend that the BOCC follow the recommendations of the Lewis County legal staff, Lewis County Planning Department, Lewis County Planning Commission, and the spirit of the public testimony given at the county hearings, meetings, workshops, court actions, etc. I also recommend that the BOCC, in good faith, follow the 3 orders given by the Growth Management Hearing Board and the 1 order of the Thurston County Superior Court Judge Thomas McPhee. Friends of Mineral Lake are very fortunate to have Gene Butler on our side. He had 50 years experience, tremendous knowledge of land use planning, and his integrity is above reproach. We've heard a church who assisted Gene. We were also fortunate to have the Washington Forest Law Center assistance with legal matters. The Washington Forest Law Center's mission is to try to preserve as much forest land for the loggers, the mill workers, and everyone else involved in forest products industry. That's all I have to say.
For the church.
I'm Roberta Church, and I live on Mineral Hill Road in Mineral, and I want to encourage you to repeal the ordinance and put the land back in the 80 acres as it originally was. have copies of the conditions, covenants, and restrictions, and the survey, which I'd like to make part of the record. And the concern that I would like to put forth, and I'm putting this forth as a concern, not as a question, is that the county do what it needs to do to make sure that the covenants, conditions, and restrictions don't undermine what the Growth Management Hearing Board and the Thurston County Superior Court put into effect. It's interesting, in speaking of the other property, Commissioner April said something about if you look at the topography, sometimes change our broad brush strokes. My concern is with Mineral Lake and with the unique qualities that it has for the people of our county and people of our state and country. And I think concerns about developing those 1,200 acres that were going to be set aside, if you look at the topography and just be logical about it, I feel confident that those properties are not going to be developed just because of their topography and how they're situated. So again, I encourage you to repeal the ordinance, and I believe that that would be the best for Mineral Lake. Thank you.
Is there any other comment? Mr. Castillo, wish to say anything or not?
Appreciate you taking the time to look at my position. I'm grateful.
My comment would be that since I've been on this board, we've endeavored to try our best to provide for the property rights of the individuals who own the property. Every decision that we've made, we tried to look at the property owners and find out what they wanted to do, and if we could legally do what they wanted to do, which is what we've attempted to do in each and every situation. With the help of legal aid, we've tried to do that. It bothers me, and always has, that a 3-member appointed board has sole authority to proclaim whether or not the actions of the elected officials are in keeping with what is dictated by the law. And it always has bothered me, always will bother me. I don't think appointed people have the same responsibilities to their citizens that elected group of people do. That's personal preference. Having said that, I see no problem with what we're doing today, which is to withdraw the forecast loan, remove from the forest land local significance designation, and move back into forest land of long-term significance. So that'll be my comment. And Mr. Casfield, I'm really happy that we were able to accommodate you in this situation, as well as they have the property back. Other comments?
Mr. Chairman, I think if there's any victory here today on the mineral property, it's Pyrrhic. I have to reinforce what Lee has said, that when one owns a piece of property, as long as they operate within the restrictions that are mandated by the state, that they should be able to do with their property what they can, so long as what they do does not hinder on the property rights of others. There are, in my estimation, some people who believe that their community should meet certain standards which are not dictated by law. I don't begrudge the motive. If the world could be kept in its pristine state and humans could be kept out, it'd probably be a prettier place. But unfortunately, mankind itself wouldn't survive in those circumstances. Changes take place. This property is owned by a group, This commission, in my estimation, made its effort to provide protection for as much of that property as possible to keep it in its state. I tell you that I sit on the Municipality River Council, and there was great concern by the River Council about the entrance to the park and what DNR is doing already on the remainder of that land that is in that entryway there. And we've been working with DNR to try to change some forest practices to keep as much of that area within framework that is suitable to the entry to the national park. And then, you know, quite frankly, in working with the Planning Commission and our original solution of taking 1,200 acres up there and keeping it preserved as forest land and scenery, in my estimation, was a good solution. I will tell you that no matter what you think today, everything thrown out, the law says that if you have forest land of long-term commercial significance, you may divide that into 80-acre parcels and you can put a house on that 80-acre parcels. That's the law. Ain't gonna change. And in that, if the developer wants to have nice spaghetti lots, they'll actually get more houses around that lake than they could in the plan that we gave them. So I think that we tried to protect it. And the board did not rule against us. The board said our plan was fine. It just said what you did was you created a class of property which now needs to be open to others in the county. That's what broke us down, not what we did with the forecastle property. So again, I think this is pure victory. I think you were going to regret what you see because I think we gave you better protection of your land. But so be it. That's how it all works.
I would like to make that unanimous with the board. It always bothers me when a small group of people and a board of unelected appointed officials interfere with an individual's right to develop his property under the law. And you force the rescinded action of a legal, rational, reasonable plan, and what will come out of it will probably be worse than what this plan allows for.
Mr. Carter, I'll ask a comment on your part. Combine the workshop and the comment period. So do we need to open a workshop at this point after we close the comment period, or can that be included in the first discussion?
If you're asking whether we can proceed to close this hearing and then go ahead to a workshop, yes, we may.
Okay, I am asking you if we could include the workshop in the hearing process, or do we need to go to a workshop?
We need to go to a workshop.
Thank you. So I will close the comment period unless there are other comments. Mr. Nelson, you've had your comment period. You've had your comment period, we've had our comment period.
No comment.
You've had your 3 minutes. So I will close the comment period and open the workshop to consider all the testimony and recommendations from the Planning Commission and staff. Any discussion regarding the proposed changes?
Mr. Chairman, I think I understand exactly what we're doing here in all three pieces, and I know that this has been before the Planning Commission, and each of these separately have had their own individual hearings and an opportunity for the public to comment. We've received writing from all of them. I understand what we're doing at this point, and I concur.
Any other discussion for the workshop? Then I will close the workshop and ask for a motion to amend the comprehensive plan as presented.
I move to amend the comprehensive plan, resolution number 12, TAC 419.
And we can do the ordinance at the same time.
And I will include then the approval of ordinance 1241.
And just so people understand what we're doing, the resolution itself is related to the comprehensive plan, and the ordinance related to the maps.
Okay, we have a motion and a second to approve Resolution 12-1419 and adopt ordinance 1241. Any questions or comments further? Oh, clerk, please read that in the record. Thank you.
Amending the Lewis County Comprehensive Plan by modifying the land use map to reflect owner requested change in land use designations consistent with the Growth Management Act, RCW 36.708. This is resolution number 12-419. Ordinance.
Go ahead.
Ordinance 1241, an ordinance of Lewis County, Washington, amending Lewis County Code Chapter 17.200.020, official Lewis County zoning map to reflect zoning changes requested by property owners consistent with Lewis County Comprehensive Plan.
Mr. Chairman, I note that not only do we have to sign both the resolution and the ordinance, but I believe the maps as well.
Is there any other comment on the motion? I'll call for the vote. All in favor of the motion, signify by saying aye.
Aye.
Opposed, nay. Motion carries.
Mr. Chairman, to see no further business coming from this body, I move that we adjourn.
I second that.
Motion made and seconded to adjourn. All